collaboration of the organization I work for, Knowledge Land, Waag Society, and the Institute for Information Law at the University of Amsterdam. And again, also we are also receiving funds from the Dutch Ministry for Education, Culture and Science. There is currently more than 250 million CC licensed objects available on the internet, more than 45 million pictures on Flickr alone. Again, this is outdated information. I think last time I checked Flickr, there were about 90 million Creative Commons licensed pictures available on Flickr, which is, if you think about it, quite amazing, because it's all pictures which are licensed under a license which allow you to use it. You don't have to ask anybody. You can just go there, type in a query for something you need a picture of, and usually, like, if it's not very obscure, you generally by now find good quality pictures which you can use, which in that sense is providing quite a lot of difficulties for professional photographers at the moment, because stock photography, which was done by professionals, suddenly get replaced by this user-generated content which is done by millions of people and like fed into this one central repository, if you want, and actually provides bloggers, but also like people who make graphic designers or publishers with a resource of freely available material that is fairly substantial. These are the countries, like the red countries are the countries where we have Creative Commons licenses at the moment. You see it's a fairly European, North American and South American and some of the major Asian countries affair. For the other countries which are white, there's something which we have like an unported license, which is a license drafted in the terms of the International Copyright Treaty, so it uses country unspecific language with the hope that it can be used in these countries, so they are used worldwide, and basically because it is something which in the first instance was written for the internet, it is something which probably doesn't really, like, information doesn't flow within countries anymore, it flows across countries, so this whole concept of national jurisdiction licenses might be even a little bit outdated. This is where we're working on. So now the Creative Commons licenses, to explain what they are actually about. Let's go, or maybe let's skip this slide, or let's go there. They are basically copyright licenses. A license is something which is a very old concept. You have the copyright, you can license your copyright to somebody else, which is basically what always happened. Like, you make a little contract, you say somebody, for example, you record a song and somebody wants to use it, you license it against usually payment of a fee. The payment of a fee is not necessarily a requirement for something to be a license. You can also license, you can give permission without requiring the payment of a fee. In the terms of Creative Commons license, you give permissions to the general public to copy your work, to do certain things, to distribute the work, in most cases also to remix the work or build works based on this work, not for a fee but for free, and you attach a couple of conditions to this. And these licenses come then in 3 different layers. One layer is, and I'm going to show them in a bit, is the human readable summary of this, which kind of like tries to hide the complexities of copyright law from the normal users of them. Then we have a lawyer readable version, which is the actual license, and fairly important for us, we also have a machine readable version, which embeds metadata with websites or within the metadata of certain file formats, and then can be read, for example, by search engines. So if you look into Google or if you look into Yahoo in the advanced search, there is options to look for material which is freely licensed under Creative Commons or other open content license. This is an example, a screenshot of what we call the human readable version, which is the thing which you click usually, like if you encounter something, for example, on Flickr, you see this little message, this picture is published under a Creative Commons license, and you click on this link. You come to a website which will look approximately like this, and in this case it tells you fairly freely what you can do with the work which is licensed, namely to share it and to remix it, and applies 2 conditions. The one in this case is attribution, which is always present, so you have to give proper attribution to the maker of the work. In the case of a picture, you put under whose picture this was, and share alike. In this case, if you make another work based on this work, and you publish that work again, it also has to be published under the same license, which kind of like applies the idea of, if I give you something to work with, I would like to get something from you, and you then produce something based on it, I would like to be free to work on that. That's kind of like a mechanism of, it's kind of like the underlying idea is a bit of viral marketing. You give people something and you trick them into, or that this share alike provision kind of forces them into also then providing material for others to work with. This is the same, and this is a lawyer readable version, which is trying to capture the same information which I had in the other screenshot in that thing. So here you can see the license grant and then A, B, C, D, E. That's basically the legal language required to express these two things. You are free to share and you are free to you are free to remix. And then under 4, like it starts and this goes down about 2 pages, is the description of these 2 conditions attached to it. So this is still fairly complex matter, but the license have been in a way drafted by experts here in Amsterdam. The Institute for Information Law is the most respected university law department that deals with intellectual property issues in the Netherlands, and they have drafted these, and so kind of like we have these summaries, and we're trying to a certain extent hide complexity for people who do not have access to lawyers to really make sense of this code. Same thing here is like a little part of the machine readable code, and if you look here, I think, no. If you look at this part here, you see it's kind of like machine readable description. It says license, then there's where the license is, and here it says always permits, requires, prohibits, and if you read the last word, you get a certain idea. So this license permits the reproduction, permits the distribution, but requires notice and requires attribution, which is basically trying to put that core elements of that license into a machine readable format. So all 6 Creative Commons licenses allow everyone to share, copy, distribute, display the work for non-commercial purposes. They all allow also transferring the work into another format. So you can, for example, take a video in one codec and transform it into another codec, or take something which you got on a tape and put it on a CD or whatever. Was that a question? Oh, okay, sorry. And they all apply the general condition that the author gives proper attribution to the original author and provides a link to the license so that other people can see under which conditions it's used. Then, whoops. The licensor can also choose if she wants to limit the rights to non-commercial uses only, or if you want to allow all of these things to take place commercial and non-commercially. And we see like about 80% of the people who use Creative Commons license apply this non-commercial conditions. So people generally seem to be fine to offer material to others under the condition that other people don't make money based on your own works, but they do seem to have reservations to actually give something away which other people then could sell or could make money based on it. On the other hand, if you look on something, so this sounds like almost like the logical thing to do. On the other hand, if you look, for example, as a project like Wikipedia, which doesn't use a Creative Commons license, but a very similar license, the GNU Free Documentation license, Wikipedia essentially allows everybody to also make commercial uses of their material. And it still provides sufficient incentive for the makers to actually contribute to Wikipedia in quite substantial amounts of time and energy. So while it is in a certain way, it seems fairly logical to restrict that, it also doesn't seem to or it can also work the other way around. So, but that's probably very much dependent on the use case scenario and what you want. In certain things like Wikipedia, it is fairly difficult for commercial organizations to make something which is better than Wikipedia and sell it then. While if you record a song and you put substantial investment in time in it, it might be fairly easy for someone else to actually put it on something, on a product, and sell that product and do that better than you do. The other condition which you can apply goes about the reuse. The author can further determine if he wants to allow distribution or performance of derivative works, remixes or not. So you can apply